If you think that a trust is just a trust, think again. Choosing the wrong trust could cost you thousands in taxes or even put your assets at risk. In California, revocable and irrevocable trusts serve very different purposes, but most people don't realize the key differences that could impact their financial future. I'm Ali Talai, an estate planning and asset protection lawyer, also author of Estate Planning for Real Estate Investors and founder of Talai Law Offices. And I have seen people ruin their future just by choosing the wrong trust. So before you make a decision that is hard to undo, let's break down what you need to know. Stick around for the most common misconception that people never talk about. So let's talk about what is a revocable living trust. A revocable living trust is a legal document that holds your assets while you're alive. And at the time you pass away, it allows for the distribution of your estate and the assets that are placed into the trust or somehow connected to it to your beneficiaries without the need to go to probate court. In California, like most other states, if you like your kids, you don't want them to go to probate court. And the reality of it is, we do a lot of probate cases in our office, and the average time it takes for a probate case to be completed from the beginning till the end, it's about a year and a half. The costs associated with probate are very expensive, and the entire process is through the probate court, which means it's a public proceeding, and anybody could go to court and find out information that we may not want them to find out. So that's one of the reasons that we want to have an estate plan that uses a trust as our main tool for the estate plan. As I just mentioned, the revocable living trust will allow the assets that are placed in there to avoid the probate. And so as you do your trust, one of the other key factors that you got to keep in mind is that you have to make sure that you fund your trust. And this part doesn't matter if you have a revocable trust or an irrevocable trust. You could have the best trust. It will do what it says it'll do to the assets that are placed in there, to the assets that are connected in there. So it's essential, imperative for you to make sure when you put your estate plan together, you transfer your assets in there. And then when you purchase a new property, you make sure it's allocated to the right trust so that if unfortunately you pass away, there will be no probate on any of the assets that you own. So let's talk about some of the key features of a revocable living trust. One of the main features of a revocable living trust is the control that you could have. In any trust, you have three main roles within the trust. You have this person who they call a grantor. That's the person who creates the trust. Unfortunately, in estate planning and trust law, I'm not sure why, but there are multiple positions or multiple roles or different trusts that have multiple different names. For example, the person who creates the trust, sometimes they refer to him as a grantor. Sometimes you may see in different trust documents a name that refers to the grantor as the settlor, as the trust maker, as the trustor. So there are four different names that realistically refers to the same person, the individual or the individuals who create the trust. The reality of it is, it doesn't really matter if you have a trust and you see settlors being used or trustors being used. I just want you to know that in a trust, you're going to have a creator. And so in a revocable living trust, if you're creating a trust, you will be the grantor of the trust or the creator of the trust. The second role is this trustee person, the person who manages the trust. And again, in a revocable living trust, in most cases, if you're creating the trust, you're going to also be the trustee of the trust. If we're doing a trust for a married couple, then usually both spouses are the grantors, creator of the trust. Both spouses are the trustees of the trust. If something happens to one spouse, the surviving spouse gets to serve as that successor trustee or the remaining trustee of the trust. And then usually within the trust documents, we appoint, or let's say you will appoint successor trustees within the trust. So now if something happens, you're not able to serve as the trustee, your spouse is not able to serve as the trustee, we have somebody appointed who could do what needs to be done to administer the trust. Third position, a third role within the trust is the beneficiary of the trust. And if somebody ever asks you, where you want to be, make sure you always pick the beneficiary. That's probably the best position to be. You get to benefit from the assets of the trust without doing any of the work. The one thing with beneficiaries that I want you to keep in mind is that beneficiaries, when we talk about beneficiaries in a trust, we really are referring to two different types of beneficiary. And again, it doesn't matter if you have a revocable trust or an irrevocable trust. In either of them, you have a current beneficiary. That's the beneficiary who is the beneficiary of the trust right now when the trust is executed. And then you have future beneficiaries. Those are beneficiaries that will become beneficiaries after the grantor passes away, after the creator of the trust passes away, or whoever had some sort of interest in the trust passes away. So you always have this current beneficiary, future beneficiary, and in a revocable living trust, when you create a revocable living trust, you get to serve as the grantor, as the creator of the trust, you get to serve as the trustee of the trust, and then you get to also serve as the current beneficiary of the trust. Even though most likely you're naming your kids as the beneficiary within the trust, they are technically future beneficiaries. We have to, not be here, then they will become the beneficiary of the trust. So structure becomes really important because when you have a trust that you get to serve in all these three roles, and then you also have the ability to cancel the trust, revoke the trust, change beneficiaries, practically do anything you want to do, that is going to give you a lot of control over the assets of the trust. This control, it would also allow you to have the need to file a separate tax return for the revocable trust. So let's say you have your primary residence, you have rental properties, you have a corporation that you run your business, and then we set up a revocable living trust and you have transferred all these assets into this trust. You have changed the ownership of your home. You have assigned your shares of the corporation into the trust. The fact that you've done all those things will not really make it different for your accountant. So if you forget to tell your CPA or your accountant that you've done all these things, it really doesn't make a difference because he or she is not going to file a separate tax return. The reality of it is there is no form. IRS does not have a particular tax form for a revocable living trust. All the income, all the assets are reported on your personal return. So when you set up your trust and we go through this whole thing and connect your assets into it, realistically, there is not anything that would have to be done differently with your income tax filing. So the reality of it is when you set up this kind of a trust, because you're the grantor, because you're the trustee and you're the beneficiary of the trust, you have a lot of control as far as what to do with the assets and, to buy something, sell something, get a mortgage, all those things. And again, when a revocable living trust is set up and you do all these things, you do not lose any control over the assets. You still have direct control over the asset because you get to serve as the trustee of the trust. You get to be the beneficiary of the trust. And if you want to cancel something, you could personally do it. The trust is revocable, meaning that you who created this trust will have the power to revoke the trust. I cannot revoke your revocable trust. Your revocable trust is pretty much irrevocable to me. Another key factor that I want you to keep in mind is that every single revocable trust that you see, just know that they will all one day turn into an irrevocable trust. And that is because, as I just mentioned, the only person who could revoke this trust is the creator of the trust. And because we're not going to be here forever and one day, all of us will be out of here, because the grantor, the individual who had the power to revoke the trust, has now passed away, this revocable trust will turn into an irrevocable trust. So now the trust is set up, you have the assets in there, it allows you to avoid probate. That's one of the main reasons these revocable living trusts are set up, because it allows you to avoid probate. And again, we just talked about all the not so great things about probate. And the reason is the why here. How is it that all of a sudden allows the whole probate proceeding to not be applicable to the assets that are placed into the trust? There's two or three reasons. One is when I set up my trust and I transfer all my properties in there, and then something happens to me, I don't own anything. I have no more assets under my personal name. And again, that's why funding the trust becomes really important. There are many, many times that we have clients that we're helping. Their parents set up a trust, but they forgot to transfer a bank account in there, or they forgot to connect the bank account somehow to the trust, or a LLC, corporation, or a rental property, or their own home. So it becomes really important to make sure you connect these things together. So one is that at the time the person who sets up the trust passes away, they don't have any assets, so there is really no need to go to probate court. Secondly, when the person passes away, this revocable living trust does not terminate, does not expire. The revocable living trust continues to live on. And so again, so we have an active and legal document in place. And in there are instructions that says, hey, something happens to the grantor and I'm not here, the successor trustee will distribute the assets based on the instruction in the trust. So then we have that instruction in there. And more importantly, that successor trustee that I was telling you about, that successor trustee has power to act as a trustee as soon as they're appointed, as soon as they accept the role as a trustee. You compare that to a will. I know we're not talking about a will right now, but in a will setting, the reason we go to court, one of the main reasons that you go to court when you have a will is that I'm going to court asking the judge to give the spouse, the children, whoever is, to be appointed, we're asking the court to give this person power to act on behalf of the state, on behalf of the person who passed away. We need court approval. In a trust setting, you don't need a court approval. In a trust setting, the trustee will become the trustee as soon as he or she accepts the role. We don't need the court to say now this person has power. So it's because of these reasons that we're able to avoid probate when we do our estate plan using a trust-based estate plan. And so a revocable living trust, it's mainly used to avoid probate, to provide control, to provide benefits to you as the person who created the trust while you're alive. All right, so let's talk about some of the limitations that a revocable living trust will have. Because this document, as I just went through, this whole thing that you have the power to revoke it, you have the power to undo everything, you have the power to remove a beneficiary, you can put properties in there and take the same property out, or any other property that you had placed into the trust before. Because of all that power that you have, unfortunately, if there is a lawsuit filed against you, this particular type of trust will not be able to provide you any sort of asset protection, because the creditor gets to use whatever powers you have. If you have the power to terminate the trust, guess what they want you to do? They're going to want you to terminate the trust and have you transfer the assets to them, because you have the power to transfer the assets. So again, the revocable trust cannot really be used to provide you asset protection while you're alive. I mentioned that these revocable trusts turn into an irrevocable trust after we're out of here. So guess what? We can do some asset protection planning for our beneficiaries. When we're gone and now the assets are being distributed to our beneficiaries, those assets could be set up in such a way that the assets are provided and given to our children or our beneficiaries in such a way that if something happens to them down the road, they get into some sort of a lawsuit, accident, bankruptcy, that the creditor will not be able to attach the assets that we're providing to our children, or at least it will be much, much more difficult for a creditor to be able to access those assets. The other limitation with a revocable living trust is that it is difficult, or I guess it's not the optimal way to do estate tax planning within a revocable living trust. In general, a revocable living trust cannot provide any estate tax planning or estate tax saving planning. If you're a married couple and now the first spouse has passed away, within a revocable living trust, we could have subtrusts that can be used for estate tax planning because that portion of the trust that belonged to the spouse that passed away became irrevocable. So by using those subtrusts, we could provide some sort of estate tax planning, but again, it's not an immediate estate tax planning. So if you have a larger estate above the exemption, it becomes a lot more important to make sure we place into the estate planning that we're doing for you some sort of estate tax planning now. All right, so let's talk about what is an irrevocable trust. An irrevocable trust is a legal document that gets to hold the assets you place in there, and at the time you pass away or at the instruction of the trust, it will make distributions to the beneficiaries you have selected. It will also avoid probate. Revocable or irrevocable, it really doesn't matter. They both allow the assets that you have placed in there to avoid having to go to probate. So they will both allow probate avoidance sort of planning. However, when we talk about an irrevocable trust, what it really means is that the person who created the trust, that grantor, he or she by himself or herself cannot terminate the trust. It's the termination of the trust that becomes important. When you have an irrevocable trust, if I set up an irrevocable trust, I cannot personally by myself cancel this trust. But I can set up an irrevocable trust and let's say name somebody else within my irrevocable trust and give that person the power to revoke my trust. So I know one of the big things I get to see online, different videos or different articles I read, there's this misconception that that an irrevocable trust, if it's set up, it could never be undone. And the reality of it is, it really depends how the trust has been written. Trusts are just contracts. You and I could get into a contract that have many different provisions in there. And as long as those provisions are not against the law, I can draft an irrevocable trust, which just means Ali, right here, I cannot irrevoke the trust. I could create an irrevocable trust and allow somebody else to revoke the trust. And the reason we would want to have those provisions in there is that even though we are setting up the structure, and a lot of times the reason we're setting up these kind of trust is to avoid estate taxes, or at least reduce estate taxes, or to try to plan some sort of an asset protection planning. So we're setting it up for those reasons, but a lot of times most of my clients say, hey, I still kind of want to have some sort of control, and we could create indirect control within these irrevocable trusts. So the reason an irrevocable trust could help in asset protection planning is that if you ever set up an asset protection trust, you set up an irrevocable trust and you transfer an asset that you used to own at some point into these trusts, if there is a lawsuit filed against you after you've set up this structure, the fact that you don't have the power to revoke and undo this trust by yourself can provide us asset protection. Because as I mentioned, the creditor gets to have the same powers as you have. And so if you don't have the power to revoke this trust, that will allow us to preserve and safeguard the assets that are placed in there. However, keep in mind, the fact that you have created an irrevocable trust and you don't have the power to revoke it that by itself is not enough. In California, if you create an irrevocable trust, if we want to get asset protection, I also need to make sure I draft this trust in such a way that does not name you as the beneficiary of the trust. California law and 29 other states say you cannot set up a self-settled trust. That's what they refer to it. That just means I set up a trust for my own benefit. California says, hey, if you set up a trust and you call it irrevocable or whatever you want to call it, even if you don't have the power to revoke it, but you set this thing up and you name yourself the beneficiary of that particular trust, if now you get into some sort of a lawsuit situation, some sort of judgment is filed against you, the creditor will still have the ability to go through that trust and take the assets that were placed in there. So when we do asset protection planning here in California, and if we're using a California trust, we'll make sure that the grantor is not named as the beneficiary of the trust. And beside the fact that it's irrevocable trust, we want to make sure you're not named as the beneficiary of the trust. And in most cases, we prefer for our client not to be the trustee of the trust. The trustee was the manager of the trust. But again, within these irrevocable trusts, we could build in a lot of other powers that would give you control over the trust. And I'm going to name a couple of them for you right now. So within these irrevocable trusts, as I mentioned, the preference is that for you, the creator of the trust, not to be the trustee of the trust, the manager of the trust. And the reality is we want to whatever extent possible, create some separation between you and the trust. And so some people say, well, I want to keep control. How do I keep control? So one way to get around this is that we will create the trust. And let's say you name another individual as the trustee of the trust. You will have the power to change the trustee, the grantor, the person who created the trust. In this example, that's you. You will have the power to change the trustee with or without cause. So supposedly we create a trust and you hire me to be your trustee. And I know that if I do something or if I don't do something, you have the power to remove me as the trustee. Again, that will give you indirect control over the conduct of the trustee. Many other times, we set up a veto decision or veto power for the grantor. So let's say I do something, I go to make some sort of distribution out of the trust, you will have an power to override anything that I have done. And again, that gives you, even though it's an irrevocable trust, even though you're not named as the trustee of the trust, it really gives you power over the trust assets. Some of the other provisions that we include, they are referred to as lifetime or testamentary powers of appointment. So we create an irrevocable trust. Again, we don't want to name you as the beneficiary of that irrevocable trust because it loses its asset protection. And so we say, okay, let's not name you as the beneficiary. We're going to name your children as the beneficiary or different individuals that you like to include in your trust. By having this limited or testamentary powers of appointment, what that allows you to do is to take the assets of the trust and appoint them to different individuals. So sometimes clients come to me and they say, well, we like this irrevocable trust option, but we don't want to be in a place that our kids will tell us, well, you could never change us. If something happens and they're doing things that we just don't agree, or we don't want to give them whatever percentage we had initially decided to do, we want to change that. And if we set up an irrevocable trust, we cannot do that. And that's not exactly true, because if we set up a lifetime or a testamentary power of appointment, you will have the ability to appoint the assets of the trust to another beneficiary within the trust or somebody that wasn't even named in the trust before. We, a lot of times, create a trust protector provision with these irrevocable trusts. As you could see, I do a lot of irrevocable trusts, and the reality of it is we could transfer and set up these trusts in such a way that it still allows you a great deal of control. However, the control is not direct, it's indirect control, and it's done in such a way that if unfortunately at some point you get into some sort of a legal battle, the assets that are placed into this trust can be shielded from creditors' attack. All right, so an irrevocable trust, who is it good for? In many, many cases, when we do asset protection, these are individuals that have come to our office and we're doing planning for them because they have a certain type of assets, real estate investors, or they are in a type of business that they are much more susceptible to lawsuits. Physicians, doctors, contractors, restaurant owners, lawyers. There are certain job positions and careers that just lend themselves to a greater possibility of things going wrong. So it's really a combination, because let's say, for example, I'm in sort of a job that I have very high liability, but I have no assets. Yeah, you probably don't worry too much about setting up an irrevocable asset protection trust or an irrevocable trust. But if you have a career that provides or could possibly expose you to greater possibility of lawsuits, and then at the same time you have assets and real estate, brokerage account, those sort of things, then yes, this would probably be a great planning for you to do, place in an irrevocable asset protection trust. The other type of clients that we help a lot using an irrevocable trust are individuals that have gathered a great deal of wealth, and now they're afraid that the IRS is going to take a good chunk of their assets when they pass away. And so it's a way for us to disinherit the IRS and try to do some estate tax planning to preserve their estate and their assets from an attack from the IRS to take anything away when they pass away. All right, so now one of the questions that comes up is which one do I choose? Do I choose a revocable trust or an irrevocable trust? And the reality of it is, it really doesn't matter to what extent your wealth has grown to, how much exposure you have, what kind of assets you have. In my opinion, when I start doing estate planning for a lot of my clients, we always start with a revocable living trust. And the reality, again, is that the revocable living trust is like the foundation of your estate plan. You got to have the foundation first before you could build the roof or, the walls and those sort of things. And the revocable living trust allows us to do incapacity planning, allows us to do planning for, if you have a minor child and we want to make sure we have guardianship within our estate plan. And when you set up an irrevocable trust, you're not going to transfer your entire assets into an irrevocable trust. First of all, you're just not going to, because you're going to need some of the assets for other reasons. Secondly, if we're doing it for asset protection, if you transfer your entire assets, your entire estate to an irrevocable trust where you have no benefits, that would make it very easy for a creditor to claim and say the only reason you did this thing was not to pay a creditor. So for two different reasons, we usually don't use just an irrevocable trust or just a revocable trust. Well, sometimes we do use just a revocable trust, and that's a case where the client is not really worried about asset protection. They're not really worried about estate taxes. Their main concern, their main worry is about their kids having to go to probate court when they pass away. They're worried about them becoming incapacitated, mental incapacity, and those sort of things. So then there are many times that we just set up a revocable trust, but in most cases, we don't just set up an irrevocable trust. We usually set up a revocable trust, and then we add an irrevocable trust to the plan, and it's intended to hold particular property or certain type of assets in there, and again we connect them together. So now at the time the grantors of the irrevocable trust passed away and now everything is going down to the children, it'll sort of connect to the revocable trust, that they'll merge together, so the administration for the children would be a lot easier. So in most cases, you're going to need a revocable trust, and then you would add an irrevocable trust for asset protection planning, for estate tax planning. Estate tax planning is always a good problem to have When I talk to clients that are concerned about paying estate taxes, I always have to remind them this is a good problem. Many people in the United States will be happy to have this kind of problem, and IRS has made it relatively easier to actually do planning to avoid paying estate taxes, or at least reducing the estate taxes that would be paid at the time we're not here. So let's talk about some of the misconceptions I hear about revocable and irrevocable trust. First one is I hear people say that a revocable trust will protect my asset against a lawsuit. And as I mentioned earlier, the fact that the trust is revocable, the fact that you who created the trust have the power to revoke the trust, the fact that you are the beneficiary of a revocable living trust, the fact that you can remove any assets that you placed in there, or transfer assets in there, the fact that you have all these powers within a revocable living trust, which is great in a sense that you can do whatever you want to do. When it comes to asset protection, it is not the best option in the type of trust that we want to use for asset protection. So the reality of it is revocable living trust will not be able to provide you with any asset protection. We can do asset protection planning for your children or for your beneficiaries at the time you've passed away, because all these revocable living trusts will become irrevocable when the creator of the trust has passed away. Another one that I get to hear is that an irrevocable trust will not allow me to benefit from any of the assets that were placed into the trust. And this is not exactly true either, because there are many different ways that these trusts can be set up that I can benefit from the assets indirectly. For example, there are type of trusts that they refer to them as spousal lifetime access trust, SLAT. And we actually do a lot of these things, a lot of these trusts. And what this type of trust allows for is that the person who creates the trust, let's say that's me, I create that trust, I transfer an asset in there. Let's say this is my book, Estate Planning for Real Estate Investors, that is doing so well, making a ton of money. It's placed in there, and all the income and revenue goes in there. And I want to somehow be able to gain access to it. If I set up this trust, the spousal lifetime access trust, I set it up, I transfer my assets in there, but I give someone else, my spouse, the ability to benefit from the assets of the trust. This combination here, the reality of it, because my spouse gets to use the income from this particular trust, I'll get to use the income as well. And that gives me indirect access to the assets that are placed within the trust. And the final misconception that I'll talk about is that I get to hear a lot of times people say, well, I'm not wealthy enough. I don't need to do a trust. Only wealthy people will do a trust or need to do a trust. The reality of it is, as I talked to you about the revocable trust, and one of the main reasons you would set up a revocable trust is to avoid probate. And in California, if you own a home that is more than $50,000, or if you have more than $184,500 in your bank account, and you don't have a beneficiary assigned to it, there would be a need to go to probate court. You may not have $184,500 in your bank account, but a lot of people, if they own a property in Los Angeles, you're not going to buy a property for less than few $100,000. Right now, condos are like $500,000. So the reality of it is, if you own a real estate, that by itself, even if it's just one property, even if the value of it is relatively low, in most cases, if something happens to you, in order for that property to pass along and go to your beneficiary, there'll be a need to go to probate court. And again, probate court could be very expensive. Even for a few $100,000 property, it still could be very expensive. It still could take a very long time. And also the entire process is public. And so for those reasons, in many cases, it'll make a lot more sense to set up an estate plan using a trust versus not doing anything, or just using a will as the main estate planning document. Now that we have gone over the differences between a revocable and an irrevocable trust in California, Did you know that transferring your property into a trust could actually cause your real property taxes to skyrocket? Check out this next video where I will show you how to avoid property tax reassessment in California. See you over there.